So our next session is going to be, again, 3 papers, 3 studies, 3 panelists. And we're going to talk about the disability application process and the outcomes of that process. So this is a discussion that we're going to be thinking about the disability application, determination, and termination processes and how they impact Social Security beneficiaries. This session will be moderated by Gina Clemens, who's the Associate Commissioner of the Office of Disability Policy, has great understanding and experience of this research. And so we thank her for being here with us today. And so with that, Gina, I will hand it off to you to lead this discussion.
Great. Thank you very much, Michael. I'm looking forward to it. It's a great honor to be able to moderate a session that is of great interest to Social Security, but to a much broader audience. And with the interest that I'm sure this is going to generate, we're going to go ahead and let's just get started. Similar to the prior sessions, we ask that you go ahead and post your Q's and A's as they occur. That'll give our panelists some time to look at them ahead of time, but we will hold them until the end to respond to them. Our first paper is by Michael Anderson, working at Mathematica, and it focuses on a high interest area of outcomes following disability benefit termination. David Newmark from the University of California, Irvine will follow, presenting our second paper on the interplay between workman's comp and SSDI. Bastian Rawestein from Erasmus University, Rotterdam, will give us an overview of the disability process in the Netherlands and how we might learn from that and apply it in the US. So all really very interesting topics. So Michael, if you want to go ahead and start us off.
Okay, I'm Mike Anderson. I'm from Mathematica, and today I'll be talking about the outcomes of former beneficiaries in the years after termination of disability insurance benefits. This is joint work with Monica Farid and Denise Hoffman, who are also both at Mathematica, and Kai Filion, who is at SSA. Okay, so I want to start with some basics on how a beneficiary might lose eligibility for benefits. And the first of the 2 reasons that I'll focus on today is medical improvement. You may know that DI beneficiaries are subject to periodic medical reviews, and those who are found to have recovered will no longer be eligible for benefits. A second reason that benefits could terminate is if a beneficiary works and consistently makes earnings above a threshold level. So in this second case, a beneficiary's medical condition is not evaluated as part of the termination decision. And these beneficiaries are also eligible for expedited reinstatement, which is both easier logistically, but also from a determination standpoint, it's more like going through a periodic medical review than an initial determination. So the bottom line is that expedited reinstatement makes it somewhat easier to return to DI than if you had to start a fresh application. So our focus today is on earnings and rates of return to DI in the years following termination of benefits. And these are outcomes that Jeff Hemmeter and Michelle Stegman-Bailey have studied for people who lost eligibility due to medical improvement. In that work, they observed terminations through the end of 2008, and they found that only about half sustained earnings above the substantial gainful activity threshold consistently in the 5 years following termination. They also found that about 1 in 5 returned to the DI program within 8 years of termination. So in this study, we are extending the prior literature in a couple of ways. First, we're looking at the outcomes of people whose benefits were terminated due to work, in addition to those whose benefits were terminated due to medical improvement. And second, we'll track these outcomes in more recent years. We observed terminations through the end of 2014. Our data go through 2019, so we're able to use 5 years of follow-up after termination. The data that we use are from the disability analysis file, and the results that I'll be showing today are broken out into 4 groups. So we have our 2 reasons for termination, either work or medical improvement, And then within each of those groups, we will separately show results for people who, prior to termination, had been entitled to DI only, versus those whose income and assets allowed concurrent entitlement to both DI and SSI. Okay, so this figure shows the percentage of former beneficiaries who returned to DI within 5 years of termination. And what we see is that almost 1 in 5 people whose benefits were terminated due to medical improvement returned to DI within 5 years. And that's in line with the prior literature. A markedly larger share of those who lost eligibility due to work returned to DI. So about 1/3 of formerly DI only beneficiaries and half of formerly concurrent beneficiaries returned to DI within 5 years. Before I go any further, I want to just note that this final group, that gold bar that you see, is a very small group of people, about 2% of all people terminated for work. And these are people who made earnings that were in the narrow range, such that they were higher than SGA, which is what's required to have your benefits terminated for work, but below the threshold at which SSI entitlement ceases. So it's a small group of people, and these are beneficiaries who worked just barely above the SGA level. But the bottom line is that people who lost benefits due to work returned to DI at a higher rate. And I think that this is almost certainly due in part to the option for expedited reinstatement, which, as I said, is available to people whose benefits terminate for work, but not people whose benefits terminate because of medical improvement. This figure shows the same measure, but it's organized by year of termination. So, for example, if we look at that top gold line, the way to read this is that 43% of beneficiaries who were concurrently entitled at the time of termination and who lost eligibility due to work in 2005 ended up returning to DI at some point in the next 5 years. So the x-axis, to be clear, is the year of termination, not the year of return. So I wouldn't say that there are dramatic trends here. For those who lost eligibility due to medical improvement, there has been a gradual decline in the share of successive cohorts returning to DI. It gets a little steeper in the years after the Great Recession, so fewer returning. For those who lost eligibility due to work, we do see an increase in the rate of return for cohorts whose 5-year post-termination period overlapped the most with the years of the Great Recession. And then again, a decreasing share of more recent cohorts returning to DI during the later recovery years. So the next 2 slides that we'll look at are related to earnings. And this figure shows the percentage of former beneficiaries whose average post-termination earnings over 5 years were above what we're calling an annualized substantial gainful activity threshold. So for reference, in 2021, that would have been about $16,000. I think it's not surprising to see that people who lost eligibility due to work were more likely to have earnings above the threshold than those who lost eligibility due to medical improvement. It is notable, I think, that there is still a large share of former beneficiaries whose benefits were terminated for work who didn't continue to make earnings above the SGA level in the years after their benefits were terminated. The other thing that stands out here is that it's clear that those who had been entitled to SSI are much less likely to make earnings above the threshold. This may not, again, be surprising. I think to be entitled to SSI, beneficiaries must have low income and assets, and that's likely indicative of a weaker attachment to the labor force. But I think it is interesting to see the magnitude of the difference by entitlement status. So again, looking at the same measure, but now by year of termination. And I think what stands out here is the pattern we see for the medical improvement group. There's a consistent decrease in the share of successive cohorts that attained the earnings threshold from going from the early years of our observation period through 2009, the last year of the Great Recession, But in the years since, a larger share of each successive cohort has attained the earnings threshold. Finally, we found a set of characteristics that were common to former beneficiaries who either did or did not return to DI or make earnings above the threshold level. I won't go into the details here, but age, duration of entitlement, SSA's expectations for medical improvement, and certain diagnoses were all correlated with our outcomes. So to sum up, our findings for people who lost eligibility due to medical improvement are very much in line with the prior literature, although, as I noted earlier, that literature includes terminations through 2008, and we're able to use more recent data. And we do see a shift in the more recent years of our data with fewer former beneficiaries returning to DI and more with earnings above the threshold. When we compare the outcomes of people whose benefits terminated for work with those who lost eligibility due to medical improvement, there are unsurprisingly different outcomes. We see both the higher rates of return, likely due in part to expedited reinstatement, but we also see higher rates of earnings. And again, people whose benefits terminated for work, it's not surprising that they continue to have earnings in the years following termination. So to me, I think what's most notable about these findings is that a sizable share of people who lose eligibility don't return to the labor force. So more than a third of people who lost eligibility due to work end up returning to DI. And I think it's worth considering whether additional provision of workplace accommodations might have allowed at least some of these former beneficiaries to continue in work. The idea behind a benefit offset policy is that it might allow beneficiaries to transition into work and avoid bouncing in and out of entitlement. To date, I think an effective implementation of that idea is still elusive, but maybe there is some way to make that work. We also found that fewer than half of people who medically recovered actually make earnings consistently above the SGA threshold in the years after termination. And SSA has explored the possibility of implementing a demonstration to provide help with return to work for beneficiaries who exit the DI program due to medical recovery. And I think the results I've shown today indicate that a sizable share of those who lose eligibility due to medical improvement might benefit from that sort of intervention. And finally, I'll just say that understanding some of the characteristics that are correlated with the outcomes that we've looked at could be helpful in designing such an intervention. Thanks.
So let me plunge in here. This is joint work with Daniel Ladd, who is currently a grad student of mine. Sorry. And we're studying, this is a question, I have one of my many hats I wear is I'm a senior fellow at the Workers' Comp Research Institute, which is based in Cambridge. And they do tons of policy and descriptive work in the workers' comp space, a lot of advice and research for specific state programs. You should think about this research that I'm going to describe, and you should especially think about this when you see the tiny, tiny sample sizes I have, as a proof of concept for my holy grail project, which is to bring actually the workers' comp insurance claims data, which WCRI has for a large share of workers' comp claims, to SSA, merge with the SSA data, and really do this. But some proof of concept is important. So let me plunge in. Let me give you a quick primer on workers' comp, just so, because you may not be familiar with it, except the broad outlines. Workers injured on the job. Hang on, I forgot to start my timer. Let me do that. Okay. Workers injured on the job can have injuries determined to be temporary or permanent. Temporary injuries are by far the most common. And they're handled through indemnity benefits, which are paid, if they're paid at all. You have to be out of work more or less a week in most states. They're paid until you return to work. They're typically total. because you don't work at all, although there's some odd cases where you might work part-time while recovering. The more interesting thing, I think, for the link to SSDI, by far the more interesting, is permanent injuries. These are injuries that can be rated as partial or total. Total, you can't work at all. Partial is a percentage. How they do that is complicated. I'm not getting into that, but you could think about somebody who has, roughly speaking, 80% of their work capacity left or something like that. Roughly lost earnings, although it differs by state. It's triggered by reaching the end of temporary disability benefits. And as you might expect, these are more complicated, right? When you're getting compensated for 2 months out of work, there's not a big deal. There's not really much scope for litigation. You talk about permanent injuries, it gets much more complicated. This is the rub. There's often litigation. There are often what are called lump sum settlements, as opposed to just paying out a stream of benefits, for the rest of your life or to a certain age or till you're eligible for Social Security. Those rules differ by state. Permanent disability settlements can sometimes, if needed, require commonly medical care, sometimes vocational rehab. And there are some issues of which I'm really going to do here, what's compensable and what's not, what was caused by a workplace injury. Some of you may or may not have had this experience with like ergonomic stuff. What just, was a cumulative injury not related to work, not the issue here. Permanent total disability benefits are the thing that are most like SSDI. It's based on an inability to work, and if it's total, that means 100%. It's a little more stringent in the sense that SSDI, technically, if you can come back, I'm not an SSDI expert, so I'm sure there are many people on this webinar who know more than I do, but my understanding is, it needn't be permanent, but, permanently disabling for 12 months. That's not the case in workers' comp. And okay, I think I covered everything on that slide. I'll move on. So here's the research questions. Do workers who get permanent partial disability benefits, or even more importantly, permanent total disability benefits, subsequently go onto SSDI? That's one question. I think this is probably I'm not quite sure, we'll see where this goes, but at least so far, I think the biggest issue, because the workers' comp system is experience rated, right? If you have a lot of injuries at your workplace, your premiums go up, and that hopefully creates an incentive to reduce injuries. If the cost is being shifted onto SSDI for whatever reason, and we'll talk about how that might happen, the experience rating system sort of collapses, and that may reduce incentives for workplace safety. That's kind of the biggest, call it a welfare issue, in the sense that people could be made worse off because of this. The rest may be all sort of distributional issues, who pays and who should be paying, right? So if workers who should be on workers' comp are getting SSDI instead, then SSDI is paying more than it should. And as it turns out, in other states, it goes the other way, where workers' comp SSDI benefits are supposed to be, so workers' comp benefits are supposed to reduce when you're on SSDI, and then the workers' comp systems may be paying too much. There is this issue of what are called offsets, and I'll explain that a little bit later. And one thing we're starting to get at in this year's project, and hopefully next year's project, if funded, we'll say a lot more about, are these offsets, that is, are benefit reductions, being sort of, when they're supposed to happen, is that being identified, and are they being done correctly? Okay, so in principle, this is coordination. Most states, SSDI benefits are supposed to be reduced because of workers' comp benefits, although that doesn't include expenses for medical or attorney fees or vocational rehab. It only includes the indemnity benefits. Some states are what are called reverse offset states. The general rule is the benefits are supposed to be reduced if combined benefits exceed 80% of prior earnings, okay? Which sounds simple, right? But it's not, and that's the problem. One problem is it's just complicated. I won't read you the quotes here because I have limited time, but basically they say that even if SSI could get all the information, it would be hard to know what to do exactly. How exactly, you get a lump sum benefit, right? So what's the, which is a one-time award. Well, okay, what's the equivalent weekly, monthly, whatever, payment that you're supposed to compare to prior earnings and add SSDI benefits to and figure out if you should offset or not. So even with all the information, it'll be complicated, but they don't even have all the information. It's hard to know what's paid. It's hard to know what's being paid. The information, as best I can tell, this is still true. It's self-reported. When you apply for SSDI, you get asked to fill out all this stuff. you're told that it's voluntary and it's self-reported. So who knows what's getting reported exactly? And again, with these lump sum payments, it's tricky. Furthermore, this sort of, I didn't know this until I started doing research on workers' comp, but now I understand all those attorneys who hang out outside subway stations and try to get you to see if you have wrist pain. There is huge attorney involvement in this system. And with respect to this dimension, and these are kind of websites from law firms basically that I'm citing here, which is sort of a weird kind of evidence, but we're sort of searching for whatever we can find here. There's a lot from law firms about how to make sure your SSDI payment doesn't get reduced, right, by workers' comp. And it refers to things, I mean, you can do the first one, a little creativity can go a long way. You don't want to affect your SSDI benefits. There's explicit reference to how to structure lump sum settlements and how many years to spread them out over. If I can get a lump sum settlement, it's interpreted as spread out over my whole life. Obviously, the per period benefits are lower, the offset's less likely to happen. There's also, if I can kind of throw stuff into medical benefits one way or another, there's no offset for those. So there's clearly evidence, this is evidence that attorneys are at least encouraging people to game the system. And gaming may or may not be pejorative. You can interpret that however you want. Whether they actually are is a harder question, and we're sort of shedding a little bit of light on that and hope to shed more as we go. So what do we know about, first of all, dual use of SSDI and workers' comp? Well, there's kind of there's a bit of a literature, I cite a couple here by Victor and by McInerney and Simon, on kind of studying how SSDI has grown while workers' comp benefits have fallen, which is meant to sort of suggest there may be some cost shifting, which isn't quite the same thing, but it's kind of related. The more direct evidence comes actually just from SSA data, and we're going to supply an innovation here. So this is sort of the SSA data. When you apply for SSDI and the workers' comp stuff you report, there are these tabulations and these sources cited here about how many people are essentially dual eligibles, getting benefits from both programs. Estimates differ slightly from these sources. Sometimes they include what's called public disability benefits, which are sort of a non-workers' comp part of the system, but they're in the kind of 5 to 6% range in more recent data. So that's SSDI beneficiaries who are also getting workers' comp. This last study I cite here by O'Leary et al. Uses one state data. They actually match kind of what I want to do. Workers' comp claim data to SSA data for a single state because they could get it for that state. It's not really the same kind of estimate. It's kind of linking any workplace injury with SSDI, which is really not what I'm after. I'm really interested in permanent disability. What do we do that's different? Well, the main thing we do is we start with the HRS. The HRS has a lot of self-reported information on workers' comp disability and receipts and disability ratings, and we do does it capture everything? No, I'm sure it doesn't. We know people are confused about programs, and workers' comp is probably the most confusing program of all the social programs. That may be a controversial statement, but I think it's true. So the reporting may be even worse. But we can do a lot of things to see that a lot of what we get actually makes sense. And then we use these various SSA files. There used to be this kind of, you could link only one to the HRS at a time, but you can get special permission to link a bunch at a whole time, which we discovered, which is great. So we can do that to find additional cases and then to study whether these offsets are being applied as best we can tell at this point. Okay, so let me just zip through a few slides. I don't have a ton of slides here. This one just says that the HRS seems to be getting pretty accurate data. What I want you to focus on that's kind of highlighted in the text here. The first column is just the HRS. This is the HRS data, the people who can be linked to the SSA data because they consented and they've, there's an SSA record. And one thing that's interesting to see here is if you look at the numbers who receive both, at some time at least, most of them are disabled at entry. And of those with a permanent disability, they're from workers' comp, this is workers' comp data, the SSA classifies them as disabled at entry. So there seems to be a pretty good alignment between what people are saying in workers' comp and what we see when they show up in the SSA data, and they have quite high permanent disability rating. This is actually reported in the HRS. They ask you if you had a permanent disability and what your rating is. It's not reported a lot. There's a lot of missing data, but that's what we have. Okay, we can think about this two ways. If we look at those who receive workers' comp, it's actually 31% of them, nearly a third, also receive SSDI. So there's clearly some important overlap from the point of view of starting at workers' comp. Relative to SSDI recipients, it's smaller. It's a little higher than the numbers from the other studies, maybe. But this suggests that SSA is perhaps not really missing too much of capturing people who did or are getting some workers' comp benefits, because this percentage, when we link the HRS data and use self-reports, is not much higher. It's a little higher, but not a lot higher than what SSA gets just from the SSA data. That was actually surprising, but it's interesting. I think you do see here things that make sense. If you're getting both, you have pretty high disability ratings. So things seem, there's nothing sort of nefarious going on here, except we want to ask, if they're getting both benefits from both programs, are the offsets being applied? And that's where it gets interesting. Now, these yellow numbers are really small. Those are cell sizes. And that is, you're taking the HRS. There's not a ton of people with workplace injuries, right? There aren't a lot of blue collar jobs anymore. Half of them get linked to the SSA data. They also getting SSDI. The numbers get really small. And this is where bringing the claims data would be incredible. But you see a couple things here. Of the people with permanent disabilities who are getting both benefits, we see around 20 for whom SSA appears to be calculating whether an offset should be applied, and either applying one, non-zero, or deciding there's no offset. We see a much larger share where, as far as we can tell, and this comes from a bunch of flags in the SSA data, which I don't think we're misinterpreting, but we're still trying to figure this out, where there's no indication that SSA is doing anything about an offset. And that seems pretty high. And it's, we sort of now have, whether you were ever in a reverse offset state or not, it doesn't seem to be applied to only the reverse offset states. So it seems like there's a fairly high failure rate to identify recipients who are compensated for a permanent disability and doing any kind of offset calculation. We're not sure, still trying to get more definitive answers on that. There is one more file, which, as far as I know, it's called the Workers' Compensation Disability Benefit File, which, as far as I know, someone from SSA may be able to correct me, is not matched to the HRS, which might have more on this. The other thing I want to say is, if you take these numbers as, even if you just sort of say where's an offset being applied, or you take these, interpret these, as, well, that's because there should be no offset. And there's other data as well from SSA, which indicates a similar proportion. There seems to be some reporting that 2/3 of the people who are getting benefits from both programs should not have an offset applied. That we find a little hard to believe. They have very high disability ratings, which suggests that people who get really severely injured on the job are usually in pretty low paying jobs. We would think their prior earnings are at a level where combine that with progressive benefits, it seems like the offset should apply, although we can't be sure. We are trying, and this is my next steps. This is the most important part here. Our hope for next year is to match this to the Social Security earnings records and be able to actually combine that with the rules of the program benefits in both programs. And for workers' comp, that means going to all the state programs, to see if offsets are being applied correctly, to try to estimate whether an offset should be applied or not, and then compare that to what SSA is actually doing. And that we think is a feasible project, which we think will be useful. But as I said, this is sort of a proof of concept for this holy grail of bringing in the insurance claims on tens and tens of millions of claims to SSA. So we're now, those little cell sizes would now be probably thousands of times bigger. It's not quite the universe of workers' comp claims, but it's close. And it's got all the details, settlements, medical expenses, attorney involvement, all that stuff. We get much more precise evidence on this, and we could answer a lot more questions. Part of the problem is the insurance companies kind of get two reactions. One is who supplied the data, of course. One is what's in it for us. The second is, what, you're going to give our data to the government, which is kind of their simplistic view of this. But we're hoping to combine kind of a pitch based on this research with some other ideas, like, are benefits adequate? How do the permanent disability ratings actually compare to future earnings, right? Are they too high? Are they too low? We think that we can combine a bunch of projects where some might make them look not so good, and some might make them look really good. We could maybe, maybe at least potentially, maybe elicit more cooperation, but that remains to be seen. But this research, again, I think at least points to the potential value of doing that by suggesting there's a lot of joint use, which we know, but we now know better by combining the HRS data. And there appears to be actually a low or lower than expected, at least in our view, incidence of offset of benefits from one program against the other.
Great, thanks, David. You had a tough challenge there, not just one, but two complex programs. And I think from Social Security, the complexity of the program is something that we don't mind losing in. So with that, Bastian, can you take us to the Netherlands and let us know about the program?
Thank you, Gina. I'm now unmuted. This is joint work with Nicole Mestes and Kathleen Mullen on disability determination in the Netherlands, because we believe that the Netherlands has some important lessons to offer to the US, and we'll try to I'll try to convince you in the next 10 minutes. And in particular, there's interest in the US on how disability determination can best reflect the functional requirements of actual jobs in the economy. And the disability determination procedure in the Netherlands offers just that. And we've tried to kind of unpack that for you and provide you with some empirical illustrations of this process. In the Netherlands, there's this direct method in which the actual functional abilities of DI applicants are related to functional requirements of jobs and other requirements of jobs. So there's this direct correspondence between abilities or limitations, if you put it negatively, and these requirements of jobs. So what we aim to do in this project is to explain how work capacity is measured in the Netherlands, and then apply aspects of this procedure to a sample of Americans. So in the Netherlands, there are, at the Dutch equivalent of the SSA, which is called the UWV, there are three important jobs, three important roles in the disability determination process, and I'll explain all three of those roles to you. First, occupational analysts maintain a database of approximately 5,500 job profiles. These job profiles measure the requirements of actual jobs in the Dutch economy, as well as tasks, but also educational requirements, work history requirements, so work experience, as well as the earnings of these actual jobs. So that's on the job side in this jobs database. On the DI applicant side, first an examining physician records both medical conditions as well as functional capacities. So it's of course not a disease, a medical condition itself that limits work capacity, but the medical condition translates in functional capacities, such as being able to read, to speak, to sit, to walk, and 102 other functional abilities. And these are recorded by the physician based on medical records, based on this whole trajectory that a DI applicant has already had in medical care, as well as a 1-hour interview with the applicant. Now, there is a direct correspondence between each of these functional capacities and the functional requirements of the jobs in the jobs database. But the occupational analyst only looks at jobs, the examiner physician only looks at the DI applicant, and there's this third role of the disability assessor who brings these two together. So who does this in 2 steps. He or she first runs an automated preselection algorithm. I'll get back to that in a moment, where job profiles, so the set of requirements of actual jobs in the economy, are ranked by their earnings capacity, so by their associated earnings. But then they are struck down from this list by an automated algorithm, which rules out occupations that have rules out job profiles. I must say, I have to be careful in this because we'll get to the terminology later on. Rules out job profiles from the set of feasible jobs, which have requirements that are not met by the functional abilities of the applicant. So this happens automatically. Then there's this remaining set of job profiles. By the way, the automated preselection procedure also strikes out jobs which have educational requirements which are not met by the applicant, and so on. So this is the aspect that's automated, but then there's a human component to this, because the disability assessor is then presented with this ranked list, ranked by earnings, of all these jobs that were not struck down by the automated preselection procedure, and then starts at the top to assess manually whether he or she thinks that a job profile is feasible for the applicant, and keeps striking down all these job profiles until at least 3 job profiles are found corresponding to three occupational titles, which is a higher level of aggregation compared with, I think, the 4-position SOC code. I hope I'm correct there. And out of the 3 highest feasible job profiles, the earnings of the second one are taken and they are considered the applicant's residual earnings capacity. So that's what, according to the DI assessment procedure, the person could still earn. Now, that number is taken as a ratio over the original earnings, the prior earnings prior to onset of disability of the applicant. And just check the time. And this is how a disability percentage is calculated. And that percentage is important because it determines DI eligibility. But at some later stage, it might also determine the amount of partial disability benefits. So it's important to realize that 2 people who present in an identical way to the Dutch SSA, to the disability determination process, who have the exact same residual earnings capacity, might differ in their percentage disability, because one person might have earned more prior to the onset of disability. So then the percentage disability of the disability related estimated earnings loss, which is the percentage disability, is greater than of the other applicant who had low earnings prior to onset of disability. So that's important to keep in mind. Okay. What we then do is we apply these insights to a US sample, the RAND American Life panel. And we have adapted these questions on educational attainment, on functional capacities, and so on, into a survey, and fielded this in the American RAND Life, the RAND American Life panel. Then we mimicked the automated preselection procedure because generously the UWV has given us access to this database of 5,500 approximately job profiles. So we were basically able to, very roughly and with a lot of limitations, this procedure that's to this US sample to determine the set of feasible jobs as well as the associated earnings capacity. Now, this relies on a whole bunch of assumptions, some of which are unrealistic, but we do think that this offers some valuable insights. Now, here's how this automated preselection algorithm works. Collaboration, there are these job requirements that describe the requirements of these job profiles, and they are related to the abilities of the DI applicant. And as long as the abilities exceed the requirements, the job profile is accepted by this automated pre-selection procedure, but could then still be struck out of the list by the disability assessor in the second stage of this process. There are flags, which means that these jobs can only be accepted if the disability assessor motivates the decision. So there are these borderline cases. And there are straight out rejections when occupational requirements exceed functional abilities. For our sample of 2,657 US adults, we have calculated their set of feasible jobs according to the automated pre-selection algorithm. So we have basically pretended that all job profiles which were deemed acceptable by the automated pre-selection procedure were in fact acceptable. And we're basically taking out this role, this very important role of the disability assessor. And then we are left with, for each of our respondents in the survey, a set of jobs that they could still do. A very important determinant in this set of jobs is their educational attainment. So that's really driving much of the variation in earnings capacity. But on top of that, there's a lot of variation in earnings capacity and in the set of feasible jobs because of these functional abilities or limitations, if you will. We have not incorporated all of these functional limitations yet, so we will do that in the next steps, but we have taken a subset and we were able to use those. And here, for 4 different levels of educational attainment, the circles indicate the number of our respondents whose estimated earnings capacity is at close to 9,000 euros per month. And then the variation on the horizontal axis is among people with a degree greater than a bachelor's degree. What proportion basically has this estimated earnings capacity of 4,000, 2,000, and so on. Finally, now that we've estimated these earnings capacities in a set of feasible jobs, we can do simulations where we basically take our sample, keep all the values of all characteristics that they have constant, but simulate how their earnings capacity will change if we give them a limitation, give all of them a specific limitation, or remove it. And then we've basically ranked the top 10 most limiting limitations. And if you lose the ability to speak, then your estimated earnings capacity of all respondents in the survey drops from over 5,000 to a little over $3,500. We can also do this, and here we show it only for the ability to collaborate. If you currently do not have that limitation, but you basically get that limitation, so you lose the ability to collaborate, that reduces your earnings capacity by about 25%. Whereas those who currently have the limitation, if they would gain the ability back again, or if they would be accommodated, their earnings capacity increases by 35%. And we can basically do this counterfactual analyses for all limitations to identify the potential gains from accommodation or rehabilitation. So that's basically what we did so far. We explained how disability determination worked in the Netherlands. We applied aspects of this method to this sample of US adults. And we are now identifying these opportunities for targeted rehabilitation and accommodation interventions. So thank you.
Great, very intriguing. I have a flight upcoming where I lay over in Amsterdam, and clearly I need to learn more than just about the tulips and the windmills. Need to learn more about the program. So definitely great presentation. And with that, we're going to turn it to Q's and A's, and to give the participants some time to answer any, submit any questions for Bastian. I'm going to go ahead and start off for a question in general to all three of you. And with that, I'm going to, let's see. So in our program, the statute requires that at step 5, where we're considering work that a claimant might be able to do on the national economy, that we have to consider the vocational factors of age, education, and past work experience. So in your own work, did you find any considerations or any differences in outcomes based on any of those factors or any combination of those? So Michael, to give others a break, I'm going to go ahead and start it with you, because you did touch on this, even though you said you weren't going to go into detail. Here I am asking you to get into detail about it.
Yeah, for sure. So age in particular stood out, and we found that age was correlated with both return to DI and earnings in the years after termination. As you just said, age is a factor in the determination decision. So I think it would be surprising if we hadn't seen a relationship between age and return to DI. That said, my understanding of the termination rules is that age 50 is really the threshold above which we would expect to see differences that are due to the determination process. And we certainly saw the largest differences in the age distribution between the returners and the non-returners at age 50 and above, but we also saw differences for people in their 40s or who were in their 40s at the time of termination as well, though they were smaller than the differences for people who are 50 or older. But earnings as well were associated with age, post-termination earnings. So people who were older at the time that their benefits were terminated were less likely to make earnings consistently above our SGA threshold. And I think probably both of these findings indicate that age is a useful consideration in the determination process.
Great, thanks, Michael. David, Bastian, anything on your end that stood out for you in regard to these factors?
I can pass on that one quickly, because we don't do any of that kind of analysis, although it may lurk in the background as the explanation for some of our findings. So I'll leave it to Bastian. Yeah,
so these considerations are very important in the Dutch determination process, as well as we've looked at heterogeneity in our own results. So just to give you this the general sense of how this works, there are 5,500 job profiles that relate to these actual jobs in the Netherlands at over 1,500 employers. So certain employers have multiple, basically are responsible for multiple job profiles in this database. So for example, we have managing a team leader of nurses and then nurses, and those are two separate job profiles. The job profiles can be grouped into 284 occupational titles. And of course, there is a nurse at one employer who does things slightly differently and needs to be doing things slightly differently than a nurse in another job at another employer. And it might be true that the same DI applicant, the one nurse job profile gets struck down while the other is still in the feasible job set. So this basically reflects this variation within occupational titles among jobs. And a job profile could have actually 10 or 20 positions of people who do exactly the same thing. As long as one substantial deviation between two job profiles or between two jobs exists, a new job profile is created. Now, the job profiles list educational requirements, at least 1 out of 7 levels of the educational ladder in the Netherlands. And if you don't meet that requirement, all of those jobs are struck down from your list of from your set of feasible jobs. Prior experience is listed as a free text field, and I've investigated. 65% of the job profiles do not require prior work experience in related work experience, while up to 35% percent does require this related work experience. And this is, of course, also basically this hierarchy that I was saying. The manager of the nursing facility might, you might need some experience there and a slightly higher or a higher educational level of educational attainment, whereas for the nurse, maybe this is not required and a lower educational attainment level is required. In the Netherlands, we also have fields of specialization in education pretty early on. You select into a certain field of education quite early, and therefore certain certain job profiles might require a certain specialization in an educational field. So that's also true. So I think, yeah, that's an answer to your question.
Okay, great. Let me just tease that just to make sure I heard it correctly. You said that if in setting your profiles, that if there was even one element different, so for example, if the nurse, I think you cited, had one education and then there was another education, you would create a separate profile. So it would be 2 nurse profiles.
Exactly. So there are minor deviations which are allowed. Let me think. No, those would still be considered different job profiles. Yes.
Okay, thank you. Very helpful. Okay, so we're going to go ahead and turn to some of the questions that we have. So I'm going to paraphrase these since you have them in the chat, you can see them. But Michael, let's go to you first. Thinking about the pre and post 2009 return to work results for the medical improvement population, have you controlled for changes in the unemployment rate?
So we did see that, I can't remember if we controlled for employment or unemployment, but yeah, for the earnings results, the county level employment rate, we'll say, was associated with the outcome making earnings above the threshold, but it wasn't for return to DI, is what we found.
Okay, great. We have another one, but we'll give you a break and go to David. So David, there's a question in here on whether when the legal counsel is working within their scope of work and trying to maximize the benefits according to their requirements, where they might stand some legal retaliation if they don't, if it's accurate to characterize that as the gaming the system rather than, I would presume, doing their job. So do you want to respond to that one?
Yeah, sure. I mean, I think as soon as I said the word gaming, I said, I don't mean that as a pejorative term. I just meant, right. So I it's a fair point, right? That is attorneys' jobs, right? And trust me, the attorneys working for businesses are, doing the best for their businesses, I'm sure. I think the issue is more that if a lot of this is happening, it might be that the offset rules need to be a little more complicated than just comparing prior earnings to benefits, period. If other benefits are like, so for example, if, it seems like the lump sum and the payout period, that seems famous last words, right? Fairly easy to regulate. If somehow medical, and I don't actually know literally what the attorneys are doing, but if somehow, things are being masked as medical expenses as opposed to legitimate medical expenses, that seems something that in principle we can get to. But I think the issue is if we can find stronger evidence from more data that, based on prior earnings and just the rules for indemnity benefits, it looks like offsets aren't being applied where they should, then this question comes to the fore more about what can be done. Again, yeah, it's not to criticize the attorneys, but maybe it's to criticize the rules.
Okay, so I'm going to just follow up on that one. So in your work, you definitely indicate that future research, not surprising, might be relevant, and that you would look at that 80%, why people aren't obtaining that 80%. So are you contemplating within that study, digging a little bit deeper into that, and maybe there trying to determine which of the offset rules are being used and to what extent? And I know this is future.
when you say which of the offset rules, just clarify what you mean.
And to your point that the representatives may be using rules to, as they should, help their claimants to just, reduce their earnings. Are you going to be digging into that, maybe providing a little bit more insight?
Right. So I would say what we can do, a small data version of with the HRS earnings files, which are not incorporated in the research this year, is get a sense of whether it seems like the offset rules, just comparing prior earnings to benefit rules to, what you should be getting based on your prior earnings by state, whether the offsets need to be applied correctly, or whether in fact it seems like when they should be applied, they aren't. And if it seems like when they should be applied, they aren't being applied, that's presumably because the workers' comp benefits are being structured in a different way, whether lump sum or more medical or whatever. That's something we can't get at with HRS and SSA data, to the best of my knowledge. That would require the insurance claim data. But if we can make this happen, the insurance claim data is pretty complete, right? You can see everything, basically every dollar that's paid out, how it's being paid out. I'm not sure the exact terms of every lump sum payment, but at least the value of the lump sum payment and things like that. It's administrative data. So a massive data set, essentially the universe. It's about 80% of claims for around 30 states. So it's a lot of claims.
Thanks. And just for the record, it was just a question for me. All right. So let's go back. Michael, do you have any insight into what happens to those who are terminated for either reason, whether it's work or medical improvement, and don't work at the SGA level, but don't reapply for DI? So basically, any other, do you know any more about what's happening there?
Yeah, that's a super interesting question. And I think our results by type of termination are different. So if you look at the people who lost their benefits because they worked, there were about 60 or maybe about 70% who went on to have earnings in the years post, and 30% that returned to DI. So, roughly all of them are accounted for. But when you look at people whose benefits terminated because of medical improvement, there's a large share who both didn't go on to make earnings consistently above the SGA level and also didn't return to DI. And so that really raises the question of what is going on with these people, what is their well-being? And we haven't yet looked more closely at those former beneficiaries, but we plan to do so.
Great, thanks. Okay, so let's try and get this other question in. So David, it goes back to you. Could some of the workman comp benefits unknowns to SSA result from the differences in the timings? For example, individuals completed the workman comps before getting SSDI, hence no offset, and then there's a speculation there.
Yes, it could. I mean, remember, most of what I was focusing on was permanent disability, and obviously, a determination of permanent disability might not always turn out to be correct, right? So I guess that would be good news if that was happening. We haven't fully exploited, and there are a number of footnotes in the paper. I guess you all didn't get the long paper. I don't know how many survived in the short paper, but in the long paper, anyway, there's a number of footnotes about things we hope to do over the next couple of months before the draft is due. And it does have to do with trying to say more about the timing. We were actually a little more focused on if we could pin down the state, which year and when it happened, so we can get this reverse offset state or not more accurately pinned down. But we could do the timing on that question, and we could see return to work in the HRS data, which would actually be a useful way to see if that's what's going on. So that's actually a good question.
Okay, well, with that, it actually turned right at the end of our spot. And while I have a number of questions that I'm definitely intrigued about and want to hear more about, including how the disability percent relates to DI benefit in the Netherlands, I'll look forward to those in the longer paper, and won't stand between the next panel and the Friday break. So with that, I really thank you all. Clearly very interesting papers, informative to all of the panelists, whether this one today, yesterday, keep it coming. Evidence is what we need in the policy side. And we're very interested in when you produce it. So thanks very much to everybody. So I'll turn it back.
Thanks, Gina. Thanks, panelists, for a great discussion. I think this is another example of how the research coming from the RDRC can draw from different disciplines, different countries, and obviously all with the intent of trying to help policymakers and program operations folks and others who are working with people to have the best information they possibly can. So thanks very much.